First of all, big thank you to everyone who's both come to the day, but also those who are joining online. We have got both myself and 3 other members of Chamber speaking today about the sequential test in flood risk and providing you with an update on 2 recent cases. We noticed that sort of in quick succession, the 4 of us were involved in 2 cases which we thought were significant enough to have this session, and I think the level of interest in it has confirmed that it was worth getting together on it. So I'm just going to very briefly introduce you to our 3 other speakers. So the first, they're in sort of reverse order there. The first talk is going to be from Charles Bishop. So Charles practices across public, environmental and planning law. He is included in the list of the top planning juniors under the age of 35. He's a regular High Court advocate and appeared as my junior in the Substation action case, and has also acted in some of the recent litigation over storm overflows for wild fish. And he's doing at the moment litigation concerning the Ministry of Defence sites which are being used to house asylum seekers. Isabella Buono was Zack's junior in the Mead case and appeared for one of the other parts as well, I think. And she does a full range of planning work across the courts and inquiry and advisory work. She's also on the list of the top barristers under 35. And then Zack, who's going to talk about some of the practical consequences of Mead. Many of you will know he has been the top-rated planning junior for the past 3 or 4 years. The various quotes that he told me not to read include that he's a joy to work with, which I can at least agree with that one. And many of you also will follow his very popular planning blog, Plannerax. So with no further introduction, I'll hand over to Zack. No, sorry, not Zack. I'm being confused by this as well. Hand over to Charles first to talk about Substation action, the first of the 2 cases we're going to present on.
Well, morning everyone. Thank you for joining. When I was, well, that's good. It seemed to be working. Sorry. When I was planning what to say this morning, I was thinking something called the sequential test, a meeting before 9 AM on a Monday. This is the sort of thing that needs a picture. And so I thought I would, sorry, I'm still struggling with the clicker. Is there something else I can press? Oh, there we go. When I was looking for a picture to use, I thought I would start with WhatsApp and I'll put it in the GIF section, see, we'll put in sequential test, and oddly enough, nothing came up. So then I Googled sequential. Nothing really came up then either, but I went down a bit of a Wikipedia hole and ended up on the Wikipedia page for sequential logic. And sequential logic is something in machine theory. I didn't really understand it, to be honest, but it did say there was an example of sequential logic, which is a remote control. And the way a remote control works and the TV set works is that when you press the channel up button, it remembers what channel you're on and it moves to the next channel. And you press up again and it remembers you're on that channel and you move to the next channel. So it's a sequence. It remembers where you are and you only move to the next channel when you press it. There's a flow that follows. Then that's some wind farms, which is what this case is about, which is substation action. The project was that was the subject of this case. A few nationally significant infrastructure projects for which development consent was granted, 2 offshore wind farms in East Anglia. And each NSIP included generating substation, and there was also a national grid substation as well. So there was 3 substations that were proposed to be built, from which the wind farm would connect to on site. And the connection hub was in Friston, a village in Suffolk, and the whole area was 46 hectares of land on the edge of the village. And part of the infrastructure is proposed to be built over land which has a high risk of flooding from surface water. And local residents argued that the applicant had not applied a sequential test to the location of the site at the site selection stage, which incorporated the surface water flood risk. And Richard and I act for the local residents in the High Court who challenged the determination of the Secretary of State to grant development consent, accepting that the applicant had complied with relevant national planning policy at the time. This is the proposed onshore element of the site, and you can see where the three substations are going to be. There's here is where they will be, and you can just very, very faintly make out on this the dark blue area is the high surface water flooding risk. Now, the case only concerned the onshore element of these two projects. The case was brought against both East Anglia 1 North and East Anglia 2, but because the considerations given by government were the same to both projects, all of the focus has just been on East Anglia 1 North. But this is all part of a much wider scheme in East Anglia. There's many other projects going on there, including 2 other offshore wind farms, maybe more than 2 actually. So it concerned 3 different sets of interlocking policy. Now, the first is one that only applies to nationally significant infrastructure projects, so anything under the DCO regime under the Planning Act. So that's National Policy Statement EN1, the overarching NPS for energy. And in the case, it concerned the July 2011 version, but there is now a new version that's come out, but that wasn't the subject of the case. Then NPPF, at the time the application was submitted, the NPPF was the 2019 version, but the NPPF was revised in July 2021 after the examination of the projects had closed, but before the examination authority had completed its report, and there was further consultation that happened as a result of the changes to the NPPF. And this jump was quite significant in the case because the examining authority had treated the change in July 2021 as a change of substance, and it later transpired and was agreed by all parties that that was an error, and actually the change between 2019 and 2021 was only a change of emphasis and clarification, but there wasn't any actual change in substance. And that change that they thought was non-fluvial flood risk, so surface water flood risk, was now included in the NPPF sequential test when it hadn't been previously. And then the third piece of policy is Planning Practice Guidance, PPG, on flood risk and coastal change. And it was the version that was dated at that time from 2014. So all the NPPF changes hadn't been updated to reflect that. PPG has subsequently been updated, and that, again, might be quite important. And I know that Isabella and Zack will probably talk a bit more about it because that was quite relevant in their case. So, judicial review brought against the grant of development consent, many grounds involved. One of them concerned flood risk. In the High Court, Mrs. Justice Lang said that within the context of the NPS, so in DCO cases, outside of the consideration of flood zones and fluvial risk, it's a matter of judgment, planning judgment for an applicant and ultimately the decision maker as to how to apply the sequential test to flood risks from things like surface water, so non-fluvial flood risk. So it isn't that you have to go through the sequence in the sequential test like you have to do with flood zones and surface water. That was what Mrs. Justice Lang in the High Court said. And she said that essentially was the same under the NPPF and the PPG. Surface water flooding is to be factored into the sequential approach, a matter of judgment as to how to give effect to this. Policy does not mean that where there is some surface water flood risk, it must be positively demonstrated that there are no sites reasonably available for the development with lower surface water flood risk. Our client appealed that decision to the Court of Appeal, and there were 2 main issues on this in the Court of Appeal. The first was whether the sequential test in respect of flood risk, as set out in national policy, is a matter for the lawful exercise of planning judgment in circumstances where no sequential approach was actually applied when looking at design. And the Court of Appeal essentially said yes and upheld the decision of Mrs. Justice Lang. There was a secondary issue as to whether Mrs. Justice Lang had erred in fact in finding that the site was at an area of not at high risk of surface water flooding, but the Court of Appeal said no, she didn't make that error. So the Court of Appeal decision is quite it's quite short, and a lot is said in really quite a few paragraphs. So I thought I'd break that down and take it stage by stage. So the first bit is the paragraphs concerning the Court of Appeal's treatment on NPS EN1. So this is just dealing with what would apply only to NSIPs. And essentially, they went through what the EN1 said and said, there's no provision here that actually requires an applicant to demonstrate there is no site reasonably available with a lower risk of surface water flooding. But a decision maker will still have to be satisfied a sequential approach as opposed to a sequential test has been applied at site level to minimize risk by directing the most vulnerable uses to areas of lowest flood risk. And that is a question of planning judgment. So beginning here to see some distinguishing features between sequential test perhaps and sequential approach. This was a question that the Court of Appeal had during the oral argument. The policy documents seem to use sequential approach, sequential test in both different ways and the same ways. And the Court of Appeal was trying to find some way of kind of reconciling that language. They then move on to consider the MPPF and PPG. Now, the core paragraph of this is very long, and this is the first part of paragraph 43, which I've put out still here. And I think it's good to take it stage by stage. So they just looked at NPS EN1, and then they now look at the MPPF and PPG. And they say similar considerations apply to the framework and to the PPG. The aim underlying the policy on planning and flood risk is to ensure that inappropriate development is avoided in areas at risk of flooding by directing development away from areas of highest risk. And then it looks specifically at paragraph 162 of the MPPF, which says that the aim of the sequential test is to steer new development to areas with the lowest risk of flooding from any source. And as the claimant had argued that the focus on this, being to steer new development to areas of lowest risk of flooding from any source, was very important because it meant that essentially the sequential test should be the same, whether it's for flood risk, fluvial flood risk, or for surface water flood risk, or whatever it is. But the Court of Appeal then said the reference to development not being allocated or permitted if there are reasonably available sites in areas with a lower risk of flooding was a reference to the sequential test as defined in EN1. So that's a reference to the policy test in relation to DCOs and is applicable to areas subject to fluvial flooding. The final sentence then deals with flood risk more generally and refers to the sequential approach, which is used in areas known to be at risk from any form of flooding. So they're drawing a distinction here. The second part of paragraph, I think we've skipped a slide. Okay, there's a slide, there might be a slide missing, I'm afraid, sorry about that. Well, yeah, there should have been one more, but it's, anyway, let's not worry about it. The court then summarised what they said and said it's apparent from the framework and the PPG that the risk of flooding from surface water must be taken into account at all stages. So it must be taken into account, but it doesn't necessarily mean that you follow a sort of logical test. As part of the aim of avoiding inappropriate development in areas at risk and to direct development away from areas at highest risk, the decision maker has to be satisfied that a sequential approach has been applied at the site level to minimise risk and direct the most vulnerable users to areas of lowest flood risk. So that's the core part. That's what they're saying the sequential approach requires at the site level, within the site, you have to make sure that where you've got areas of higher risk, that the most vulnerable uses are not on those areas, but you direct them to lowest areas. But ultimately, how you go about doing that, that's a question of planning judgment for the decision maker. They then summarise the position. Provisions of the NPS EN1, National Planning Policy Framework, and PPG don't require that wherever there is a risk of flooding from surface water, an application for development consent must demonstrate there is no other reasonably available site with a lower risk of flooding. They then turned to apply that to the facts of this case, and they said, well, the applicant here had considered surface water flood risk at all relevant stages of the process. The claimants had argued that those stages the surface water flood risk hadn't been considered at the site selection stage when choosing where to actually build the substations. But the Court of Appeal said it's artificial to separate that stage from the design stage on the facts of that case. Site selection here considered whether to select a site where particular parts would be located in areas of lowest risk of flooding and where suitable mitigation measures would be adopted to address the risk where located in areas of higher risk. And they said essentially you can meet the aim of preventing inappropriate development in areas of flood risk through a combination of the location of parts of the project and by mitigation together. So in summary, these are the sort of four principles that emerge from the substation action case. First is that risk of flooding from surface water can't be ignored, it does have to be taken account at all stages of the planning process. A sequential approach must be applied at the site level, so on the site, to minimize risk and direct the most vulnerable uses to areas of lowest flood risk. And that sequential approach, however, is a matter of planning judgment, and so the court will only review it on ordinary public law grounds and ultimately only disturb it if it's willfully unreasonable, we say, basically if it's perverse. And there is no requirement, this is the sort of crucial bit, there's no requirement that wherever there is a risk of flooding from surface water, an application must demonstrate that there is no other reasonably available site with a lower risk of flooding. So the sequential test as it applies to alluvial flood risk, going through flood zones, that approach doesn't apply when you are considering surface water flood risk. Now, the question is what next? Well, going back to the remote control again, which is ironic given this one hasn't served me particularly well today. But you might ask, well, is sequential test, is that really what's now happening in surface water flood risk, or is it something else? Is it just one of the considerations that goes into the mix? Can we really say that there's a sequence that you have to follow where you don't move on to the next stage until you've crossed the first stage? Well, our client has sought permission to appeal from the Supreme Court, but that we haven't got a decision on whether or not the Supreme Court wants to hear the case. The NPS EN1 and the PPG have been revised. And going forward, how might you reconcile the relationship between the importance of location, of where you put the site, and mitigation on the site? I just want to talk about one further case, which isn't reported, but this was a judicial review of a grant of planning permission for an infill development on a housing estate in Brent. And in the officer's report, no sequential test has been applied. Didn't happen at the flood risk assessment stage. Officers didn't ask for it. It wasn't applied. It wasn't even considered whether or not they should apply it. Where part of the site included high risk of surface water flooding, I acted for the claimant in this case, who is a resident on the site. The argument was the council had simply ignored the sequential test. But the council argued that substation action meant they actually didn't need to carry out the sequential test because they said there was no need to look for reasonably available alternative sites. The decision was, the JR was refused permission on the papers, but was renewed orally. And at the permission stage, the judge rejected the council's argument and said that substation action was about the outcome of the sequential test, rather than whether it was required at all. And further, and quite importantly, I think going forward, the judge said the terms of the PPG are now different, which means that there might be the substation action case might not necessarily have been decided in quite the same way as it would be now. However, the claim was ultimately refused permission on the basis essentially it would have made no difference because the flood risk had been sufficiently mitigated on site. So even if the council had been required to go back and consider it, then it would have reached the same outcome. This is just a decision on permission. It isn't binding in any way at all, and it also, I should say that the judge's comments on the council's defence wouldn't be binding even within the context of the own case. Claimant has sought permission to appeal on the refusal of permission on this basis. It would have made no difference, but this just gives a flavour of how courts might be approaching substation action going forward on a more usual kind of development. So with that, I'll now be handing over to
I'm going to be covering the other case on our case update today, which is the Mead and Redrow case, which were two linked statutory challenges to two different inspectors' decision letters, one brought by Mead Realisations and the other by Redrow Homes. So starting first with the Mead case, that was an application for outline permission for up to 75 homes on a site in North Somerset, all of which fell within Zone 3. The local planning authority had refused to grant permission, Mead appealed, and an inquiry was held. At the inquiry, there were only two reasons for refusal still left in play. The first was that Mead had failed to demonstrate that the flood risk sequential test was passed. And secondly, even if that test was passed, the exception test was failed. Ultimately, the inspector agreed with the council and decided to dismiss the appeal. I've put a couple of key paragraphs from his decision letter on the screen. But he rejected all of Mead's various arguments that the other sequentially preferable sites were not true alternatives. One of those arguments was that some of those sites wouldn't come forward on the same timescales as the appeal site, for example, because there was national grid infrastructure that would need to be relocated. And there were also arguments that some of the alternative sites were not appropriate for the same density of development as the appeal scheme. So they'd said you shouldn't be looking at town centre sites because they were talking about suburban low density housing on a greenfield site. Ultimately, the inspector says, no, all of those sites are sequentially preferable. The sequential test is therefore failed. There's a clear reason for refusal within the meaning of 11.1 of the framework. And ultimately that means that planning permission should be dismissed. Then moving on to the Redrow decision briefly. This was a bigger scheme. It was for up to 310 homes plus other things, including a mobility hub, community facility on a site in Bushy in Hartsmere. This site, some of the site fell within flood zone 1, some within flood zone 2, some within flood zone 3, and actually all of the built development would be within flood zone 1. Unlike in Mead, the sequential test issue arose very late in the day, sort of at the stage that proofs were being exchanged for the inquiry, and inspector ended up making a cost decision against the council in relation to how that was handled. But ultimately, she did find that the sequential test was failed. Again, similar points on why the developer said that the sequential test was passed in this case, to do with timescales. Redrow owned the appeal site, so it could bring it forward very quickly. Inevitably, any other site, it said, would take longer because the acquisition process would take up more time. And there were also arguments at the Redrow inquiry to do with how you should deal with disconnected smaller sites. So the council had said you could be looking at groups of sites that weren't physically next to each other, whereas Redrow said the package of benefits that the Redrow scheme would deliver couldn't be disaggregated in that way. In particular, if you think about open space provision, it doesn't make sense to sort of split it into 3 or 4 little bits, because the point of it is to have it all in one place. The inspector dismissed those arguments, found that sequential test was failed, and again ultimately refuses to grant permission. So those are the decision letters. Then thinking about what policy test the inspector was deciding. That's the key paragraph in the current version of the MPPF, paragraph 168. In the judgment, different paragraph numbers, but the text is the same. And we're in particular looking at that second sentence of that paragraph, which is talking about not permitting development if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding. Questions as to what that means. And then on the next slide, we've got corresponding text in the PPG, which gives you a bit more guidance. 3 important points there, I think. The first, that we're looking for sites with a real prospect of them being developed at the point in time envisaged for the development, so something on timescales there. Secondly, that we're told that you can look at smaller sites, provided they're in a series. We'll come back to that, and also parts of larger sites. And then that last sentence, also important, that the absence of a 5-year housing land supply is not relevant to the application consideration of the sequential test at the decision-making stage. So lots of issues arising from that. First one, because we're looking at both the PPG and the MPPF, what's the relationship between the two? Can the PPG change national policy? Can it go further than the framework? Can it set additional requirements that make it more difficult for developers to show that the sequential test has been passed? Second one arising that we're going to have to understand is, what's the proposed development that needs to be assessed? Are we looking at sites that can accommodate exactly the same development as the application scheme, or does it just have to be development of the same general type, of the same general quantum within a range? And relatedly, how do we deal with that smaller site issue? If you're proposing comprehensive development with a package of benefits delivered in one place, is it appropriate to be looking at smaller sites when they're not physically connected to one another? Third question there on reasonable availability, and again, timescales. Do they have to be exactly the same as the application's proposals, or are we looking at whatever's reasonably available in an objective sense? And then finally, on needs, how do needs fit into the overall picture? In particular, if you have a scenario where you can show that there are maybe 3, 4 or 5 small number of sequentially applicable sites in flood risk terms, which could accommodate, say, 500 homes between them, what do you do if needs actually run into a much larger number? There are needs for, say, 2,000 homes over the next 5 years. Do you nonetheless have to refuse permission, or is there room for a more flexible approach than that? And the first issue, the relationship between the PPG and the MPPF, I think many had generally understood, as the name suggests, the MPPF sets policy, and that the PPG sits beneath it as providing guidance in relation to that policy. But in the Mead judgment, Mr. Justice Holgate makes absolutely clear that the PPG has the same legal status as the framework. It can and it does make policy, and it does that irrespective of the fact that it's not consulted on and can be changed without warning. He also said that irrespective of the fact that other judges in other cases had said things like that the PPG is subservient to the MPPF and is not policy. What Mr. Justice Holgate says we need to do is to look at the PPG and the MPPF together and use the PPG as an aid to the interpretation of the framework, even where the framework text came earlier than the PPG, so we can look back retrospectively. And so far as possible, we should try and read the two together harmoniously. In some contexts, though, he says harmony won't be possible because it's perfectly open to the Secretary of State to publish PPG, which is inconsistent with and which amends the framework. So far as flood risk is concerned, though, he said the two are consistent with one another, so we can read them together. Ultimately, he says what is an appropriate alternative site and what's reasonably available will be matters of judgment. And he says that when you're looking at alternative sites, you don't have to find one that would accommodate something exactly the same as the application or appeal scheme in all of its various particulars, including form, quantum, and timescales. He says precise alignment is not required. The decision maker is entitled to take a broader or more flexible approach than that. He does say something important on that smaller site issue though, because he says when we're looking at groups of smaller sites, they shouldn't be sites which are disconnected or bear no relationship to one another. And he placed quite a bit of emphasis on that word series in the PPG, that he said implies some kind of relationship. And finally, on the need issue, he says that needs may be relevant in one of three ways, or at least in three ways. The first is that needs might be relevant when you're setting your search area, because needs for some kind of development, for example, a school, might be geographically constrained. Secondly, needs might set some of your search parameters, because the need might dictate what size of site you're looking for, or for example, what density of development you're proposing. Those are specific needs, he said, and they're relevant to the application of the sequential test. But he said then thirdly, general needs may also be relevant when you come on to the overall planning balance, because if you encounter that issue where there are needs which far exceed what can be accommodated on the sequentially preferable sites, that will be, he said, a significant factor to weigh in the overall planning balance. So it might be, he said, that you add additional weight to the benefits, or conversely, less weight to the harms associated with flood risk. So that's just a reminder that even though breach of the sequential test may give rise to a clear reason for refusal within the meaning of 11D1, that's not the end of the analysis. You still need to carry out an overall balance and may still find that permission can be granted. On the facts, both claims fail. Redrow got part of the way there because Mr. Justice Holgate indicated that the inspector had taken the wrong approach to the smaller site issue, but that wasn't enough to get them home, because her approach to the larger sites was, he said, legally sound, and therefore there were sequentially preferable sites, albeit only 3. Redrow hasn't appealed, so that's the end of the road for their claim, but Mead has appealed, in particular on those issues related to the relationship between the PPG and the framework. A decision on that is still awaited. And on that cliffhanger, I'll hand over to, I think, Richard on some practical tips.
Thank you to Isabella and Charles before her for their summary of the cases. Zack and I are going to sort of divide up the practical aspects of all of this. So I'm going to start and look at some of the practical aspects of substation action and what that means for the application of the sequential test and engaging the sequential test. And then Zack's going to come in on Mead and Redrow and the question of how do you apply it in practice. So I think the first comment to make is that it's clear from substation action that what we have in the MPPF is not, the Court of Appeal found, not a requirement to exclude sites which have a lower risk of surface water flooding at least. And it must also, on that reasoning, taken at its most narrow, it must also include other sources of flooding that are not fluvial flood risk sources, so groundwater flooding and so on. That's the ratio of substation action. And as Charles indicated, that's a proposition which we're appealing against, and we're asking the Supreme Court to consider that point. But 1, that's probably going to take some months to decide. 2, the Supreme Court only grants leave in a case which it thinks is of sufficient importance, and it's unclear whether this Supreme Court will think we want to get into the weeds of national planning policy on flood risk. So we will see, but we obviously say it's wrong, but for practical purposes, it's right until somebody says otherwise. I think the key point to take from how we stand at the moment is on the MPPF is that wording in the MPPF is the same now as it was when it was considered by the Secretary of State in substation action. There's no change there. There might be an issue with the PPG, which I'll come back to in a moment, but the MPPF, as it stands today, means what Lord Justice Lewis said it means in substation action. So you can use that as your starting point. I have myself some doubts about where that leaves fluvial flood risk, because the language in the NPPF does not distinguish fluvial flood risk and surface water flood risk, but the court's reasoning is only related to other sources of flooding. But in fact, the language of the NPPF is the same for both. There's also a wider question, I think, which is a point that we've picked up in our application to the Supreme Court, unsurprisingly, which is where does it leave the sequential test more generally? Because of course the sequential test appears in the NPPF also in the retail context, and it also appears in lots of plans for other tests. So for example, it's quite a common policy in waste plans to have a sort of sequential approach to site selection. The sort of big question which I think arises now is, does the PPG alter the ratio of substation action? The PPG was updated after the Secretary of State's decision on the developments, and the revised PPG has a lot more detail on what the sequential test means in practice. If we didn't have Mead, we didn't have that judgment of Mr. Justice Holgate, the easy answer I'd give you is that the PPG can't alter the meaning of the NPPF, because that's precisely what other High Court judges had said since 2019. However, Mr. Justice Holgate says something more nuanced in Mead itself, which is that it's intended to supplement, and it shouldn't be viewed as sort of contest between the PPG can only give guidance and the NPPF must set the policy. You don't have to view it in that way anymore, he says. Both are statements of government policy. And that means that potentially the problem in substation action, the issue in substation action, could have been addressed through the PPG. However, when you read the PPG, it takes the same structure as the NPPF to the question of whether the sequential test is engaged. The language is a little bit different, but there is, for instance, a complete circularity between what is said about the sequential test, that phrase, and the sequential approach. Indeed, if you start to read into the section that says, how do you apply the sequential test to particular developments, you have to click on a hyperlink to go back to the section headed the sequential approach, not the section headed the sequential test. So there's no distinction in that 2022 version of the PPG between sequential test and sequential approach. The language is the same. The clarity that perhaps is provided by the PPG is it creates, in the section on applying the test to particular applications, it creates what appears to be a presumption that you do apply the sequential test in any case where there is flood risk. And it basically sets it up as exceptions. So you don't apply it if it's been allocated and tested through the allocation, or if there is a low risk from all sources. So that seems to be potentially the area where you could say, well, the PPG now makes it clearer that you should apply the sequential test unless it's been allocated or there is a low risk from all sources. But frankly, that question, I think, is very much open for debate. So how's that debate going to be resolved? Well, the answer probably is a High Court case is going to have to deal with those tensions, or the Supreme Court is going to have to address what substation action actually means, and we'll have to wait and see. So that's where we are with the law. Obviously unhelpful for those that are trying to work through the planning system to know that the law is perhaps not as settled as we might hope. Where do we go in practice then, which is really the thrust of what I want to cover, and then what Zack's going to cover in terms of the Mead case, and then what we'd like to open up to the floor on. Well, I think that the way to analyse this at the moment is that in any given case where you're dealing with at least non-fluvial flood risk, it's a matter of planning judgment as to how you apply the sequential test. And there are two ways of applying that or answering that question. The first one is the substation action analysis, which is, well, you've got to bring surface water flood risk into your analysis on the sequential test, but it might not be determinative. That's going to be a question on the particular facts of the case. Or alternatively, there's a slightly broader approach, which we saw in a case called Wathen Fayed, which was a judgment of Mr. Justice Mould, as he now is, where he said, well, actually, it's a matter of planning judgment as to whether you apply the sequential test at all. Do you even open that box in any given case? So there's a big area of judgment. How am I going to deal with surface water flood risk, or in Wathen Fayed, groundwater flood risk, on the facts of the case before me? Am I going to apply the sequential test? And if I am going to apply the sequential test, am I going to treat it as a site selection exercise or a design question? If you're making an application, promoting a scheme, I think you can argue for and justify an approach which says we don't need to exclude other sites. We don't need to show that there are sites which have there are no sites which have a lower risk of surface water flood risk, at least. I think such an approach obviously is engaging planning judgment, whether that's a planning judgment being undertaken in a local authority or a planning judgment being undertaken by an inspector. So therefore, you're going to have to persuade that decision maker that they should exercise their judgment in that way. I think some of the routes that in my view, viable routes to persuading a decision maker along those ways. First of all, if you can show that the surface water flood risk is removed by the development that you propose, because of course, in many cases, surface water flood risk is indicated on the Environment Agency plans because there is a flow path, and those flow paths can be modified through the development that you're proposing. So can you exclude the surface water flood risk such that if you drew that map after the development, it would be a new map? It would look different because you'd modify the land and therefore the flow path. I think it's also open to say that there are compelling reasons to justify this site coming forward. In other words, that notwithstanding a potential failure under the sequential test, you should nonetheless grant permission for this proposal. And I think in this regard, it's worth remembering that in the retail context, in a case called Asda and Leeds, the Court of Appeal have already confirmed that that might be a legitimate approach, because applications under the retail test should be refused if there are sequentially preferable sites, should be refused. The Court of Appeal said should be refused does not equal must be refused, and you may conclude that this is nonetheless a good site for this development. So you can persuade the decision maker that even if there are sequentially preferable sites, nonetheless, you should not apply the sequential test to exclude your site at that stage. So that's a logically prior argument to the one that Zack's dealing with, which is the question of how do you look at the need for the development in applying the sequential test? You can say, well, actually, my development is so good and so important in this location that you just shouldn't worry about the sequential test. And then the final argument, which I think is the more nuanced one, and the one I know has troubled a lot of people, is if you can't remove the surface water flood risk or the groundwater flood risk through your development, is it enough to build around it? And of course, those were the facts in Redrow on a different form of flooding. But the facts were that the risk was related to only part of the site that wasn't to be developed. And of course, in many cases, you will have a site which has a mix of flood risk on it. Now, is that alone enough not to apply the sequential test? I think that's going to be a more difficult argument because of the way in which the PPG is framed. I think it's more difficult to say you shouldn't apply the sequential test because I'm not going to build on that part of the site. I think that doesn't fit with the two cases that we've seen. It doesn't fit with the analysis in the Court of Appeal and substation action. It doesn't fit with Watham Fired, but nonetheless, it might be part of that sort of basket of factors. I'm going to address the risk. I'm not going to build on the area of risk, and there's a good reason to pick this site anyway. So it might be one of the factors that you put forward to avoid carrying out the full sequential exercise. I think the big caveat, and the reason why I don't think substation action is sort of a panacea for dealing with surface water flood risk and other non-fluvial forms of flood risk, the big caveat is that it's all couched in planning judgment. So the Court of Appeal saying, well, this was a legitimate judgment for the Secretary of State to reach on that development is not the same as the Court of Appeal saying you don't need to ever exclude sequentially preferable sites when you're dealing with surface water flood risk. And for me, that's the key warning, that in any given case, you're going to have to persuade the local authority or the inspector. And in practical terms, in many cases, I think the answer is to both say you don't need to exclude other sites, but also carry out some form of assessment of those other sites in the way in which Zack is going to deal with. So is the sequential test engaged in practice. I'll hand back over to Zack to pick up how do you apply it in practice.
With great difficulty is the answer to that question. Even just going through some of those issues towards the back end of Richard's talk there, you'll be aware, if you're following the appeal decisions on the sequential test over the last, say, 6 months, that the planning inspectors are reaching completely different, mutually irreconcilable views on the topics that Richard's just gone over. So take, for example, the red line issue. Yes, I'm building in an area of flood risk, but my houses, say, are going on this part of the site and the area of flood risks on that part of the site. In those circumstances, is a sequential test required? Some planning inspectors have said yes, and some have said no. And so far, the issue's not troubled the High Court directly. So we are at a bit of an impasse so far as the clarity of the guidance and the policy goes until something changes. But let's just assume for a moment that, notwithstanding your attempt to run the sort of arguments that Richard has just outlined, with, say, with the authority to try and persuade whoever it might be that you don't need to do a sequential test, that your arguments come unstuck and you do need to do one. How then are you supposed to do it? How can the sequential test be met, assuming that you have to undertake one? The answer is with a laser focus on the criteria that are going to govern the exercise. And high level, might sound obvious, but just to start at the beginning, the broader the criteria are, the harder your test is going to be to pass. The narrower your criteria are, the easier your test is going to be to pass. What criteria are we talking about here? Well, there are several. First, an obvious one, again, the starting point is to actually understand the nature and extent of flood risk that crosses your site and to understand that in detail. That might be a simple thing to do if you're talking about fluvial flood risk and you're looking at flood zones, say, but it's not an easy thing to do necessarily if you're discussing, for example, surface water flood risk or groundwater flood risk or something else where there's not a standardized EA metric to enable site-by-site comparisons. So that's step one. But beyond how you go about analysing the extent of flood risk that covers your site, the key criteria that I'm thinking about when it comes to defining your sequential test parameters: catchment area, huge. Nature of the development, lots to say about this in a moment. Any necessary spatial or locational characteristics that flow from the nature of your development. Site size, timescales for delivery. Those are probably the biggest. Just having a think about some of those in a bit more detail. The first, nature of the development. We know, in the context of, for example, the Finney case on section 73, that a lot of you will know all about already and that Richard was involved in, and the inability to alter the description of development through Section 73 applications, you may remember. There's been a trend, particularly since Finney, to make those descriptions of development as broad as possible, as bland and generic as possible, taking out things like quantum of development or types of development, just putting, residential or whatever at a particular site, removing any extraneous detail. But here's the difficult bit. In the context of the sequential test for flood risk, detail is your friend. Because remember, under 168 of the framework that Isabella showed you on her slide, what we're after are reasonably available sites appropriate for the proposed development. What elements contribute to being reasonably available turns on exactly what the proposed development, quote unquote, actually is. And in short, the more niche, if you like, the better. For instance, if we're talking, say, about residential development, if it's a scheme designed to provide not just homes in general, say, important though those are, but say larger family homes, as the case may be, and the needs for that particular subset of your provision are picked up on and justified within your planning application materials, you're going to find it much easier down the line, if you've got to do a sequential test, to justify excluding from your site search, shall we say, town centre sites, which would support flatted development or whatever. If it's a larger scheme, as the Redrow scheme that Isabella and I worked on was, with multiple elements to it, not just houses, but houses along with different sorts of houses, open space, land for primary school, mobility hub, all of the rest of it. You need to explain in your application materials what the elements are, which obviously you would do anyway, but more than that, why those elements are interdependent, why they sit together, why they have to sit together. The interdependency is important. It might arise for lots of different reasons. Obviously, we can all think of examples. It might be for functional, practical reasons, say the need for a school is generated by the pupils who are going to be living on the houses in the scheme, one obvious one. It might be for planning policy reasons, e.g. we've got a policy here that requires us to provide a GP surgery or whatever. It might be for financial viability reasons, e.g. the affordable housing here is only going to happen with the market housing or whatever, again using residential examples. Either way, all of this interdependency needs careful unpacking in the planning application. The more specificity, the better. The more elements the scheme comprises, the better. The less generic, if you like, the better. Because if you do all of this stuff, it becomes easier then to cast aside what would otherwise be potential alternative sites for your development. And also potentially to narrow your area of search. And that's the second thing that I wanted to talk about, obviously enormously important. Catchment area. Critical, clearly. And to tell you all what you already know, the narrower your catchment area, the fewer sites you're going to pick up. The fewer sites you're going to pick up, the easier your test is going to be to pass. So defining the catchment area is a huge step in the application of the sequential test. Step, of course, that we get scant guidance on in the PPG, no guidance at all on in the MPPF. As a matter of generality, you might assume, you'd be right normally, that you'd be expecting to cover, let us say, the local planning authority area within which you are. That would be the norm, maybe as a starting point, but that's only a starting point. There are plainly good reasons that might justify going narrower than that. On the other hand, there are also reasons that risk justify going broader than that as well. So it cuts both ways. How you frame what catchment area is appropriate for your sequential test will depend in part on the nature of your development, which is why I've spent some time on that just a minute ago. And as Isabella's touched on, there's a need case that can sit behind how you justify the sort of development that you're proposing, the catchment area that goes along with that development. And again, the more narrowly tailored your scheme is, which I've been over, the more localised the needs are that you're seeking to address, the greater justification you can draw on to try and narrow your area. Not like I've said there's a flip side. The flip side is if you're trying to meet a strategic regional level need, your catchment area may end up being drawn much more widely than, say, the individual LPA's area. As Isabella has said already, in our Redrow case, Mr. Justice Holgate made clear that need, how you define the need, what the need is that you're seeking to meet, can be relevant to how the catchment area is defined. So again, be clear in your applications about what needs specifically you're trying to meet. Take another example. If in the residential context, if you're thinking about a build to rent or a co-living scheme, focusing on, say, the needs of professional commuters or whatever it might be, expressing that through the needs work that supports your planning application is important, because it might mean that you are able, say, to justify limiting the scope of your search, of your site search, your catchment area, to a particular radius from major train stations or something like that, just as another example. It's about trying to narrow the scope of the catchment area so far as you can to make the test more passable. And this too links to the next topic I wanted to touch on, site size. Site size. Now, I mentioned the Redrow case for obvious reasons that was involved in it, but just to give you a flavour for how we approached it there, that was a site for 310 homes, land for primary school, a mobility hub, open space and all of that. How do you approach, if you're looking at alternative sites, this topic of site size? Our site had a size. Do we say that any site that's a little bit below ours in terms of site size must be excluded because it's just too small? We didn't do that. We took what we thought was a precautionary approach. There's no guidance on this, unfortunately, and different planning inspectors have sort of hazarded different guesses as to how it might go, but you can't really criticise the inspectors because they're not being guided by central government on how to do this. We took as a sort of working rule of thumb that we would look at sites which were up to 25% smaller. Rule of thumb. And the High Court in Redrow thought that seemed okay. But, you know, it's hardly a prescriptive, rule. But it's that kind of thing. So don't fixate on the precise site size. You've got to be practical. You've got to be reasonable. So you've got to allow for the possibility of smaller sites. In the end, we had no maximum site size. We had a lower limit, but we couldn't have a higher limit. And I'll come back to that in a moment about the larger sites, because those are in some ways more difficult to deal with than the smaller sites. What about the idea of a series of smaller sites, which is something that Isabella's touched on already? To break that down, Isabella's already said this. Mr. Justice Holgate looked at what the PPG says. It might be you can bring your site forward through a series of smaller sites. And that Mr. Justice Holgate thought that that word series connotes some kind of link between them, which is actually really helpful. Because if he'd not said that, the argument that we were being faced with by local authorities is that, well, you've got 300 houses, okay, we'll put 10 over there, we'll put another 50 over there on a completely other side of the district, we'll put another 50 up there, and if that were an appropriate approach to the sequential test, you've created a policy that is almost impossible for a larger scheme to pass, because there's always going to be another site that could take a few, homes or whatever it might be. But this idea of a series connoting some sort of connection between the smaller sites makes it much easier to pass. It will normally be possible to exclude individual or unlinked, if you like, smaller sites on the basis that there just isn't any such connection. They're just too small, too isolated, can't be done. What about the larger sites? The issue will often be, depending on obviously what it is that you're promoting, but unless you're promoting something on a strategic scale in the thousands of homes if it's residential or whatever, the issue will be whether or not your development could itself be incorporated into a much wider development. And this gives rise to the next issue. The next issue is timescales for delivery. Isabella's touched on this already. You'll remember what the PPG says. Isabella read it out to you. Reasonably available sites have to have a reasonable prospect of being available at the point in time envisaged for the development, for your development, at the point in time envisaged. Now, if you were reading that, not as a lawyer, but as a normal person, you might think that that suggested that if it is, it sits behind you in the pecking order in terms of timelines of delivery, well, you can exclude it then. That's certainly what we were suggesting to Mr. Justice Holgate, but that's not, the courts have said that it's not quite as simple as that. The courts have said that the test doesn't require completely aligned timescales for delivery. So let's say that you've got a larger site and it's say a year behind yours or whatever in terms of likely timescales for build out or whatever. That's not fatal. You've got to exclude that site. You can't just, you've got to deal with that site. You can't just sort of exclude it out of hand. On the other hand though, if you're looking to deliver say in a few years, say if you're at outline or maybe shorter if it's a detailed application, and you can evidence that in your planning application materials. And let's say the much larger site that you're worried about is on a trajectory of a decade or more, which is, absolutely not unusual. That site's not reasonably available to you for your development, and it should be able to be excluded on that basis. Of course, you're going to need evidence on build-out rates, likely build-out rates, both of your site and also of the larger site or sites in order to show that. But as a matter of principle, if you can show that it is way off in the weeds versus whatever it is that you're bringing forwards, you should, in principle, be able to knock it out. As I say, establishing all of this stuff is going to require evidence. It may be that the larger site's being master planned for, say, residential, and if you're promoting an employment use or a commercial use or whatever, it may be that the site's not reasonably available to you for the use that you are seeking to bring forward. Okay, but you're going to need to evidence that, and how you evidence that is actually, it's when you think about it, if you've not been through it before, it's quite a delicate, subtle and potentially cunning matter, because you're going to have to touch base with a range of developers, landowners, site promoters across your area to extract from them information on what their intentions are for their own land and how far down the track they are in terms of delivering that land. Now, 5-year housing land supply for residential cases. Of course, this applies across the board, and it's not just about residential cases, but the PPG talks about 5-year housing land supply not being relevant to the application of the sequential test. There's a lot more to say on it than that might suggest. It is actually relevant, notwithstanding what the PPG says, to the overall planning analysis of whether or not you're going to get your planning permission or not in the context of a sequential test. Even if you end up doing all the things that we've been over and you still fail to exclude every single site in wherever you are in your catchment area, you just can't exclude them, you've not got the evidence. That's not necessarily fatal. Tallies with what Isabella was saying and also what Richard was saying about the application of planning judgment. And just to sort of give you an example, I mean, there are obviously thousands of different examples you could think of, but the Redrow site that we're talking about is in Bushy, as Isabella said. The relevant authority is Hertsmere, and any of you who have done any work in that part of the world will know that it's one of the Hertfordshire authorities for which the outstanding housing need is not measured in the tens or the hundreds, but the thousands and thousands. They've got one of the worst 5-year housing land supplies in the country. So their need, the need case for residential land, say in Hertsmere, is in the thousands, many thousands, just over the next 5 years, let alone wider, longer plan periods. In the Redrow case, in the end, we failed to exclude, as Isabella said already, 3 sites. There were 3 sites that we failed in the end to exclude as being sequentially preferable to us in flood risk term. 3 sites, when we know that they're going to need hundreds of sites providing thousands of homes in order to meet their minimum needs. That's on their own evidence, uncontested. When circumstances like this arise, when you've got a powerful needs case for whatever the development is that you're bringing forward, and you can show the authority that, yeah, even if there's 1 site or 2 sites or 5 sites or 10 sites, which might be above us in the sequential test, if we do one, the courts have told us in the Redrow judgment that the fact that there is this whopping great need that will require necessarily land that sits below you in sequential preferability, that is a, quote, obviously material, language that lawyers use, obviously material consideration, which can justify granting planning permission anyway. I think that that's an important thing to take out of the Redrow judgment, because as Isabella's mentioned this already, but if you look like I do at the framework in paragraph 11 and you see that references to clear reasons for refusal in 11D1 of the framework, it talks about clear reasons for refusal. You look at footnote 7 in the framework, and on that list, which includes things like AOMB, Greenbelt, Heritage, on that list, is flood risk. It's on the list. And we know that, you know, if you go down on a, say, Greenbelt, clear reason for refusal, well, that's probably the end of the story. But actually, when it comes to flood risk, what the courts have said is that, yeah, it might say clear reason for refusal, but actually, in reality, it's not necessarily determinative. You can say in your ultimate planning analysis, yes, well, we failed the sequential test, but look at all these other things, look at the benefits, look at the paucity of land in order to meet the benefits in sequentially preferable locations, look at, say, the inevitability of using land which is less preferable than our site, for whatever reason. Planning permission should still be granted, and the courts have said that that's an obviously material factor, the meeting of these needs, which could lead you to that conclusion. So what are the key lessons, taking a step back? I mean, we are still in the weeds of this. I'm sorry to say that was a term that Richard used. There's going to have to be more High Court litigation. The appeal decisions are quite painful to read because they all say different things at the moment. So there's not a standard approach. There's the inspector's training manual that says some things about this. Of course, that has no status at all. It tells us on the front cover, and the things it says aren't the same as what the PPG says, nor are they the same as what inspectors are actually telling us at appeals. So it's a very difficult area at the moment, which is probably why you're all, yeah. Anyway, things to say, agree your parameters if you can with who? Oh, there's a whole nother story. The LPA, the LLFA, maybe the EA as well. I mean, the primary focus is probably going to be on the LPA, but even just by raising this, I've given rise to another issue that I'm not going to talk about unless you want to ask questions about it, which is actually who's responsible for regulating the execution of the sequential test, because of course it sits between multiple different bodies, LLFA, LPA, EA, and indeed others. So, but try and get your parameters agreed, and the reason for that is that if you do, then you're going to save an awful lot of pain down the line arguing about it all at a planning inquiry. You try and get them agreed in a way that suits you up front. Particular care required from the very beginning, from the outset, from the DAS, the planning statement, all of the wider planning documents, about how you conceive your development, how you describe it, but also beyond the just technical description, how you're justifying it, what is it about, what needs are you seeking to meet and why. As I say, the more niche, the better. Relevant to catchment area, relevant to how you think about what sites are reasonably available, relevant to timescales maybe. You need to be explicit and tailored on the needs that you're seeking to meet and why the different elements of your scheme, if there are different elements of your scheme, are all coming forward as a package. Be proportionate on things like site size. If there are sites that can't be excluded, on the face of it, you're going to need to make contact with, e.g., the other promoters of that land or whatever, landowners, developers, in order to work out what they're doing in terms of timescales. And in the end, even if you do all that stuff and you fail to exclude all the sites, think about the needs case. In the residential situation, think about 5-year housing land supply. Obviously, the same goes for employment land, commercial land, or whatever sort of land that you're bringing forward. Right, that's it from me. Thank you very much indeed.
Thank you, Zack. So questions. I've got 15 questions online, but let's ask in the room. Does anyone want to kick off on questions? If not, I'll go to an online one. Go on, yes.
Bellway Homes. I think one thing I've taken from this and reading the judgment, ultimately this is all quite grey. People have got planning news for you saying you ask a lawyer answers, but ultimately the thing from these judgments is a lot of it is down to planning judgment as to how, and it is open to the decision maker to be flexible if they want to be flexible. If they want to see a development come forward on a brownfield site or whatever, for a reason, they can apply it flexibly to enable that development without sort of causing themselves legal problems.
I think that's
minimizing the potential for
from my perspective. I think that's a fair summary. It's the sort of the provisions as they've been interpreted in those court judgments. They don't have that clarity of a binary answer, and therefore it is turning on planning judgment, and in any given case, obviously the authority might be persuaded, whether it's local authority or an inspector or secretary of state, they might be persuaded and they might not.
Agree.
I think that probably comes down to some needs, and my experience is when you're in an appeal decision, and when you're looking at these competing appeal decisions, everything either you're getting through and the inspector's looking for a way through, or everything starts crumbling, and you're probably going to be losing on the sequential test as well as on some other grounds. So it's down to sort of the whole scheme and whether or not it's being welcomed as a form of development, unfortunately.
Just to touch on your reference to brownfield, and this wasn't the focus of your question, but one might assume that when we're having these discussions, we are thinking more about, say, edge of settlement, greenfield land or whatever, but we're not. We are talking, as lots of you who know, we're talking about city centre development, town centre development too, which on regeneration brownfield sites, which I must say might come as a bit of a surprise for some. Sites that are going down at the local level for these reasons, and so even sites that on the face of it you'd expect to be pretty popular with officers are going down at appeal on sequential test.
Can I just pick up a couple of the online points? I'm just going to try and pick up a few of them before we finish. One of the points that's been raised in a couple of queries is your description, Zack, more niche the better, but obviously in the context of hillside, lots of developers are being told you want to be careful to make sure you're not being overly specific in your scheme to ensure you don't get into problems when you come in with later drop-ins and so on. Yeah. So how are you practically reconciling those things, or is that in the too difficult box?
I think with enormous difficulty at the moment. I think that we've got, and I mentioned Finney as well, which is another reason that beyond hillside that we've been trying to keep things like development descriptions, as I say, generic rather than specific. But you can't necessarily do all of these things at the same time. You ultimately have to, I suppose, decide what your greatest area of risk is and design your scheme accordingly. And there will, though, by doing one thing, you will necessarily increase your risk profile on the other. And I guess in the meantime, we cross fingers that the amendments to Section 73 through the Levelling Up Act come in so as to make the hillside problem a bit less of a problem than it has been for the last couple of years. It's not a great answer, but it is difficult. It really is murky at the moment. What do you have a thought about that?
No, I think it's a challenge. I think one of the ways to do it is to make sure that you've described the main components, but without being overly specific about them. So you need to make sure that you've got the key development components listed, but don't bother with the 8,000 square meters of X and 200 square meters of Y. Get all of that detail out, but say it's an application for houses, schools, and pub or whatever it is. But there is a tension there. Okay. Any another question in the room? Go on, Nikki.
Nicola Wilder. Just going back to plan making and how. I'm finding it struggling sometimes of hard to find it. Would you say it's best for local authorities to be doing their own sequential approach, or could it be a bit of sustainability appraisal with a bit of the SRFA? And I'm just wondering, sometimes looking back at plan making, how much this is actually done for all sources of flood risk, and how exposed are.
Big time. And the problem is that Isabella mentioned that the PPG distinguishes allocated, in fact, I think you mentioned, Richard, that the PPG talks about allocated sites as being a kind of site that you wouldn't have to do a sequential test at the DM stage. Normally is the answer to that. Not always, because lots of these issues are coming up with allocated sites when you look back, just as you've said, to the SFRA, say, and let's say, as is very often the case, the SFRA dates back to 2017 or 2016, years before the PPG was updated or whatever. It may well have done a sequential approach or indeed a sequential test in respect of fluvial flooding, but you're not going to find anything in it on ranking the sites in terms of surface water. So it's
You're then still at risk.
You're at risk. I'm sorry. I know. I mean, there are appeals that have gone on exactly that have raised this scenario. Unfortunately, there is a risk. Quite painful that. So you'd like to think that the allocation would, but then, maybe then though you're into the sort of territory Richard was talking about, which is we've got a site, let's say, that's allocated for, let's say it's allocated for good reasons, and we need this site to come forward. You know, yes, there might be some ponding on the site or whatever, some surface water flood risk, but actually you can't make an omelette without all of that. And we're going to have a perfectly sound drainage scheme and all the things Richard was saying. It should come forward anyway, you might be saying, but it is still a risky area.
But don't bury your head in salt.
No, don't, because the problem is now it's such a prominent area, and loads of, not just one, it started as, sorry there's a pun coming now, but a trickle, and it's turning into a flood or whatever of appeal decisions in the area. If you end up burying your head in the sand and you get refused locally and it ends up coming up on appeal like it did with the Redrow case, you're going to feel like a right plonker. That's the problem.
I mean, the other thing is on applying, that question really was about applying the sequential test to a site which has been allocated through the plan. But of course, when you come to its application, it may be that you're in a pretty good position on no other sequentially preferable sites because your site has been allocated. So there's already a priority that's been given to it. Maybe that's part of your analysis on other sites, which links to one of the questions online actually, which was, you know, reminding us really that there are often other planning grounds to exclude the other sites. So that obviously gets a bit complicated, but in many cases when you're in the sequential test and you're looking at reasonably available sites, you're excluding those sites on planning grounds. You're not worrying about who owns it and whether it's going to be available to you. You're saying, well, it's, you know, next to a grade 1 listed church and you're never going to get planning permission to build 300 houses on that field. And it's those sorts of points that I think, you know, need to be borne in mind as well. And again, the plan process may help you with that, because you may find those sites have been excluded in the plan SA on other grounds, other planning grounds. Anything else in the room?
Ollie Lloyd, JMS Planning. I had a question about how to apply this in the context of affordable housing. Particularly in dealing with catchment areas. For instance, I'm dealing with an LPA at the moment that say, because their SHMA sets out the whole LPA and even further to do a catchment based on sequential test for the LPA. However, when you're applying something like a rural exception policy that is local connections, there's a bit of a conflict to be had in how exactly you apply that. So I was just wondering if you could provide any thoughts about that on the basis of trying to persuade the LPA what the best approach is. I know this maybe goes back to the needs.
Yeah.
I think it probably does.
I think it does, and I think affordable housing it's a really good point, and I don't think just for a local exception side that affordable housing need is one of the levers you might be applying to say that the need is more localised than the district as a whole, because I'm building these houses in this location and it's going to meet pretty much everywhere at least in the southeast of England and most other parts of England, a vast immediate local affordable housing need, which I can't meet by building at the other side of the district.
Yeah. I think you're right. You obviously, with affordable housing need, you could look at it generic kind of LPA wide, but obviously you can also zoom in and do, you know, say for households on the housing register, they express preferences in terms of settlements that they want to live at. And this comes down only to how you paint your needs case in your planning materials. You might want to do as a bespoke sort of local housing needs study that looks at what, you know, in your whatever it might be, and says, yeah, actually, we need to meet the need here. This is the need that our scheme is being brought forward to meet. And then it is a planning judgment, just as you've said in the end, and as Richard said, but it's trying to be as persuasive as possible to narrow that catchment area by being as niche as you can, as I said, on the sort of needs you're trying to meet.
By the way, if anyone wants, we said we'd finish at 10, but we'll take a few more questions. If anyone needs to leave, please don't worry about leaving. I know everyone's got busy days at the start of the week. Thank you everyone for coming. I'll just do a couple more questions because we've had a lot online. One of the issues that keeps coming up in questions to me, both on this and more generally, is this question of applying the sequential test where you've got part of the site is within a zone, but very clearly that part of the site is public open space or access road, and that's the area that's identified at flood risk. do we apply the sequential test or don't we?
Do you have a pop at that one?
I think as you said earlier, I don't think there's a clear answer, and in the end, it's going to be a question of judgment. And some inspectors are not persuaded that you shouldn't. So I think you. I mean, as we said earlier on the Redrow scheme, how the scheme had been designed so that it would, or the built development would be within flood zone 1, but that didn't avoid the entire problem.
Some inspectors take that view that if it falls within the red line, it's fair game. The inspector's training manual tells them to take that view. But I've been at inquiries where, without any debate at all, the inspector said, "Yeah, but in your parameters plan, that's all going to be open space anyway, isn't it?" And we say, "Yeah," and he says, "Well, fine." And so at the moment, I'm sorry to say, there's this question about the red line is really important, and it comes up quite a lot. But there's no clear answer. All you can do is design things as best as you can. Obviously, you want to put in, say, if you're an outline, you'll want to put in some parameters plans that are fixed and conditioned to control this, so you can actually say, we are not building over there, And obviously, if you're a detailed scheme, that's clear anyway. And at the moment, we've just got to try and do the best we can to make those arguments. Last thing is, one of the mischiefs that's being created by all of this uncertainty is the wonky red line problem. So one thing that lots of us are now advising people to do is, because of all these risks, because of the grey areas and the uncertainty, just exclude it from your red line completely. Carve it out. Now, that won't always be possible, but obviously sometimes it is. And sometimes if you want to retain it for some sort of wider open spacey habitats or whatever, you might be able to manage that through, say, the wider blue line in the section 106, but have it out of your red line. I mean, it's all getting a bit silly and artificial, but that's the sort of thing that we're needing to do, or at least to think about doing.
Yes, go on.
Just taking that on a step, do you see any problems with having two applications, the one for your development and another for change of use for your open space element that's got the flooding in it? In your development part doesn't have any flood risks. You then apply for a separate change of use for your open space. Do you see any problems with that? Just carve it out.
Just carve it out.
I mean, I think that might be a legitimate approach if you can find a way to make it work. I think a local authority is always going to be a bit circumspect about that. I think you're going to have to approach it with an openness as to what you're doing, to say that you want to make sure that in terms you're avoiding the area of flood risk. That's the deliberate strategy. And here is your separate application for development, which can appropriately be cited in the flood zone that you're dealing with, or manage the flood risk that you're dealing with, and approach it on that basis. I think it's possible, but you're going to have to get the linkage there. You're going to have to look at the 106. You're going to have to look at the conditions. How are you going to make sure that it all comes forward as a whole? Yeah. But yeah, in principle, red line, blue line, 2 applications.
Or maybe 1 application. If you can, obviously you need an application for the built development, obviously, but you might, depending on what you're actually doing in your open space, you might not necessarily need to apply for anything there. Depends. But yeah.
Okay, let's have one more question. Go on.
Thank you. Blue Racetrick Centro Planning Consultancy. Coming back to Brownfield for a sec. Yeah. If your development very clearly improves what's currently a dangerous situation, in that you've got highly vulnerable uses in the functional floodplain at ground floor, you're fixing that by raising it all up. Do you even get as far as the sequential test?
Yes.
And you deal with it through the exception test?
Yes. Because the problem is that the sequential test read strictly. I mean, look, I agree. I think this is anyway. I'm not going to go into what I think. It's 10:10 already. But it looks at the site as is. And when it comes to your drainage mitigation, flood risk management schemes or whatever, those might be good arguments to say that will grant us anyway because actually we're improving the situation or whatever. But the starting point is to take the site as it is, unmitigated, untouched, and deal with it on that basis. That's the way the policy is framed at the moment. And if I ran, luck or whatever for the day and actually had the chance to change this, that's one of the things that I would change. I would change it so as to say that you, when deciding whether or not you've really got to go down the path of a sequential test at all, you should be able to look at the post-development universe, not just the pre-development universe. But that's not the way currently that the policy is framed. So get lobbying.
But it might be a matter that goes to that judgment.
Yeah,
at
for
the
sure.
outset. That's the thing.
Defo.
And I think for me, that's quite an important point, that you may say to the authority, but given the risks and the uncertainties, I think the general strategy that I think is the better one is to run both. So I'm not sure we need to be in the sequential test at all, because actually we're going to, on any analysis, going to be delivering improvement in overall flood risk. But if we did have to apply it, here's the reason why we'd still have to be at this side. Right, I'm going to wrap it up there. There are, I think there were, by the end of that discussion, 33 questions. So answering questions seem to provoke more. We will look through those, and at least some of them I'll provide some bullet point answers, which will circulate to all attendees so that people don't feel as though they've missed out. But thank you very much